I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello, and welcome to Just Justice. My name is Jessica Henry, and I'll be your host. Today, we have the pleasure of talking with Ruth Greenberg. Ruth is an attorney based out of Massachusetts who has devoted her entire career for criminal defense, almost exclusively for the poor, in both state and federal courts. Her practice focuses on post-conviction relief of all kinds. She's been heavily involved in the push for compassionate release in Massachusetts and in the recent decision by the Massachusetts Supreme Court prohibiting life without parole for emerging adults under the age of 21. Ruth is the founder and former director of the Boston University's Compassionate Release Clinic and served as an instructor in the Wrongful Convictions Program. She also has served as an adjunct faculty for both the Boston University School of Medicine, teaching forensic neuroscience, and the Boston University School of Law. And she's been a guest lecturer at MIT in the area of law and neuroscience and in the area of corrections and disability. Ruth is an honors graduate of the University of Chicago and earned her law degree from the University of California, Berkeley. Ruth, welcome to the show.
It's an honor.
So, you have been at the forefront of two different kinds of second chances, medical parole and litigation about life without parole for emerging adults, which expands who gets an opportunity for release. And I just can't wait to talk to you about both of those areas. They're so disparate. And honestly, the way I found you is because I was doing research about medical parole and your name sort of popped up. And little did I know about your expertise in the emerging adults area of second chances. So I really can't wait to talk to you. So Ruth, let's just get right into this. I'd love to talk with you first about this idea of medical parole. And I'm wondering if you could just set the stage for us briefly. Tell us what compassionate release is, which is what you call it, or what medical parole is, which is what some state statutes call it.
So the big answer to your question is society changes. And in some areas, society is growing kinder. It used to be believed that punishment was pure revenge, and that people who did bad things should die suffering and in chains. But that is now no longer a common or enforced belief. Now, people, voters, legislators, constitutional scholars are coming to understand that that's too cruel and, frankly, also too expensive, because the cost of keeping an old dying person in prison, who, after all, is no longer dangerous to other people, can run in the hundreds of thousands of dollars to provide even the most minimal constitutionally required care. So these two things, the forces of compassion and the forces of fiscal responsibility, come together, and they create a legislative need for some kind of relief for people who are old, people who are sick, people who are disabled, people who are infirm, people who are dying, terminally ill, who don't present a danger anymore, to be released from prison and to live in the community for their last few final harmless years, rather than be an expense for their care to the state. That's what compassionate release is all about. Because we have a system of states and a federal system. We have federal compassionate release for federal prisoners. Each state has its own separate state compassionate release system. But it wasn't always so. Not all states did. The state in which I work and practice, primarily Massachusetts, was either the 46th or the 47th state to have such a program where old, sick people could go home. And so, because of the way prohibitions against cruel and unusual punishment work, constitutionally speaking, Massachusetts was really compelled to create a structure whereby the old and sick could get out.
Right. And that happened in 2018. So I think it was 47th. Massachusetts was the 47th state, I think, to have any kind of compassionate release program. And it was passed through an omnibus crime bill, right?
That's correct. So we had a legislative pressure to make this happen. And we also had a constitutional imperative because our state was one of the few places that didn't. The punishment imposed upon people by forcing them to die in prison was unusual as well as cruel.
So there's Massachusetts. It was kind of this outlier. This law gets passed in 2018, but you're a criminal defense lawyer. So how did you get involved in compassionate release in Massachusetts?
Well, I have been doing post-conviction litigation since 1992. My goal was truly to reduce the incarcerated population in Massachusetts, which is my state. And I'm happy to say that the number of people incarcerated in the prisons of Massachusetts has gone down from 10,000 to just over 4,000 in my working lifetime. How is this accomplished? Right now, I'm accomplishing it by chipping away at the bottom, that is, the very young, and chipping away at the top, the very old. And my eventual goal is to have one guy left in prison who's 52. That's my plan. I can't get the state to abolish prisoners. I just take them out one at a time from the bottom and the top. My next hope is for the state of Massachusetts to find it constitutionally impermissible to give these lengthy sentences to people who suffer from mental and emotional impairments. Something like the federal constitutional prohibition against the death penalty for people who are intellectually impaired. Currently, federally, you can't execute a person who has an IQ plus or minus 80 or so. It's a low number, but plus or minus, with some wiggle room around the edges. It seems to me that in Massachusetts, we shouldn't have life without parole for those people either. So then I will have removed from the criminal justice system the young, the old, and the impaired. I'm chipping away.
But the issue of compassionate release specifically, right? I love the vision. We talk about the vision later, but just staying with this compassionate release for a minute, you got involved on the constitutional side because somebody came to you and said, Ruth, I've got a situation with somebody who's incarcerated, who's really sick and has no way to get out.
Yes, I was asked.
Can you tell us about the case that kind of propelled you into this litigation?
A young man who was very, very sick, who was going to die. A man with a young person who had failed claim of defense of others. Defense of others means you kill somebody trying to protect someone else. If you use too much force, killing someone trying to protect somebody else, you're guilty in Massachusetts of manslaughter, which has a sentence of up to 20 years to serve. So this person, a young man, sentenced young with 15 years to serve, incarcerated, had a terrible kind of gastrointestinal cancer. He was doomed to die. He was a wonderful young man. He had completed the prison education program. He had been in the dog training program. He was a Boston University college graduate within the walls. He was a wonderful young man. And he was doomed to die. And we were trying to get him home to his mom. And that was the beginning of the constitutional argument that said Massachusetts was required to create a compassionate release statute. But really, it happened because the then leader of the House in Massachusetts, a wonderful legislator who ran into trouble later, but still Sal DeMasi, pushed for compassionate release. He was very interested in the welfare of humanity as well as the public fisc. And it was his determination to have compassionate release. He saw the constitutional problem, and he also saw the innate cruelty and the enormous cost. And he pushed it through. So in Massachusetts, we are now a very protective state. Our compassionate release statute doesn't have what's called a carve out. In some states, some kinds of prisoners can't get compassionate release no matter what, either sex crimes or crimes against children or homicides. Those people in some states are ineligible. But now here in Massachusetts, even though we're late to the party, our tent is large and we allow everyone to apply and be admitted to compassionate release. At one time, we had 37 first-degree murderers out on compassionate release.
You've been called the mama, this is a quote, the mama of medical parole. And I'm wondering, how did you get that title? It sounds like a very affectionate one, but how did you become known as the mama of medical parole?
Well, back in the day, my day, we used to say mother was only half a word. I took cases when people asked me. I have been a practicing homicide lawyer in Massachusetts. I don't always win. I win more than many other people win, but that means I lose still most of the time. I mean, the average rate of success for a murder conviction on appeal in Massachusetts hovers between 3 and 4%, which means you lose a lot. Even if you win 3 times as much as the average lawyer, you lose a lot. And I knew a lot of people who I lost early in my career and they were getting old and they needed this.
And so they would call you. And I also gather that you're someone who always picks up the phone when you get a call from the jail. Is that right?
That is true. My children hate me. My friends hate me. I always pick up the phone. If it's an incarcerated person, I always answer.
Yeah. And that's a beautiful thing because a lot of times people don't answer.
It's hard. People have a different setup than I do. People work very hard. I'm not meaning to diss the defense bar.
No, of course not. Of course not. But it's an amazing thing. Mama of medical parole. So I'm teasing you about being the mama of medical parole. Well, part of that nickname came from the fact that you were involved in Buckman versus Commissioner of Correction, which is a Massachusetts Supreme Court case that was decided shortly before the pandemic was even on the horizon, right? It got decided in January 2020. What was that case all about?
At the beginning, starting with Alex Phillips, who was one of the first 2 medical parole petitioners, I think the first. The other, I think, was a gentleman named Ben Lagur. But Alex Phillips was the first filing and the first litigation, and the Department of Corrections didn't like it. Prisons want to keep their prisoners. It's almost Darwinian. Even prisoners whose care is expensive, generally prisons, at least now, or at least in Massachusetts, they contract out the medical care in bulk. So that means the Department of Corrections pays a fixed fee to a medical provider, and then the medical provider has its own budget. So it doesn't matter to the Department of Corrections itself whether prisoners are expensive because it comes out of the health service provider's budget, not out of the prison budget. So prisons want to be more. They want to be bigger. They're like any growing, greedy, organic thing. They want to have more buildings, more employees, more staff, more power, more union power, more closeness to the governor, more influence. They want to be bigger. My job is to make them smaller. So I was opposed to the Department of Corrections. The Department of Corrections did everything possible to frustrate the purpose of medical parole. And in this, the Department of Corrections, which is the executive branch of government, was supported by the Republican governor. Your younger listeners won't remember who Willie Horton was. But Willie Horton was the ghost of Mike Dukakis' presidential campaign. He was a prisoner released on parole who did terrible, terrible things.
Actually, it wasn't even on parole. It was on a furlough program.
So no governor who has a hope for a future career wants to be haunted by someone who he freed, his administration free, who goes on to do a bad thing. The least risky course for the executive branch of government is to let no one out ever.
What happened in Buckman? Like, what was that case about?
What happened in Buckman was the Department of Corrections was requiring people asking for medical parole to create their own release possibilities, to put together all their own records, and to find a safe place themselves for them to go, to apply to the place, to fund that place, to create a list of doctors. The department was reading the statute to place an enormous burden on a petitioner for parole to basically arrange their own release. And they couldn't do it. No one could pass this bar. They weren't allowed to make phone calls out. So it was hard for them to find their own nursing home. They couldn't line up doctors in advance. They had no telephones or newspaper. They couldn't write to anyone. It was impossible for the prisoners to plan their own release and to document their own conditions in such a way that they could qualify. This was contrary to the statute. The statute said the duty was on the prison to help these prisoners try to get out. And the department was just created a set of regulations that said, not our problem, you do it. and the prisoners couldn't. So that's what Buckman was about. And Buckman was decided by a unanimous court under the leadership of a great Chief Justice, the late Ralph Gantz. And the Buckman case said the prison has to do this. The prison is obligated to create a plan, to make a record, to sometimes itself ask for someone to be released, that the duty is on the executive branch to help prisoners who qualify for release get released and find a place for them to go.
When we're talking about release, we're talking about medical release. We're talking about people who are so ill that the prison can't care for them. So it does seem preposterous that the burden would be on them while they are so incapacitated in prison to make a plan for themselves. It just doesn't seem reasonable. And clearly the court agreed with you. So you won that case. I mean, Buckman was a big victory, as you said, a unanimous victory. And I saw actually that you also had written to the court a few months later when COVID hit. You wrote this really wonderful, compelling letter to them saying, I'm writing on behalf of people I represent and maybe some people I don't, urging you, court, to really think about how you're defining who's eligible for medical parole. Do you remember that letter that you wrote?
I do not.
It was a pretty kick-ass letter. I have to say, I was like, this is awesome. Where you basically said, on behalf of all the folks who are incarcerated and sick, and behalf of all the personnel who's going to have to navigate this in the midst of COVID, I'm really urging you, court, to look at the standards that you are imposing and interpret them broadly to impact the most number of people.
The medical parole statute was not designed for COVID. The entire regulatory scheme, the statute itself, the state had no idea that such a pandemic was coming, and the prisons were not able. Many, many people here died, and many people here suffered. It was a terrible time to be a prisoner in Massachusetts. And during that time, I must have worked thousands and thousands of hours because people who were in the population that were deserving of medical parole under the old statutes were astoundingly at risk in this new situation. It was an emergency because if you were a person with a breathing problem or a heart problem or an asthmatic, COPD, if you caught COVID, you were going to die. You were qualified to be released because of your condition, but we had to get you out fast. And that's another reason Buckman was important. Buckman enforced the absolute time limits release rule. And it was critical. We worked night and day to really saving lives to get the people who were qualified for medical parole, at least under the old rule, out before they died from things they wouldn't have died from because they weren't terminal, but they were impaired. That was the place we needed to be. And we did the best we could with what we had.
Yeah. I mean, it's amazing what you did. And it sounds like you were really impactful in that time period and also more globally on this issue of compassionate release. But I just wanted to ask you about what's happening now. So Massachusetts passes a statute in 2018. There's some good case law that comes down the pike. You're right in the middle of all of it. And there's this organization called FAM, and they rank states. And so they gave Massachusetts an A- for their compassionate release policies because this new statute and the cases that sort of interpreted it seemed really good. But what's happening now in Massachusetts with this issue?
Our court shifted. Right. We had, for a while, Chief Justice Gantz died an early and tragic death. The court shifted to an all-Republican bench appointed by the governor who specifically hated the medical parole statute. It was almost a litmus test for appointment to the bench. We got an anti-medical parole bench. And during a long Republican administration after Chief Justice Gantz died, and the court shifted. So the original medical parole statute appeared to contemplate that if the Department of Corrections would not release a person, that person had recourse in the courts, that you could file and litigate in the courts, and we did, and ask a judge to say the Department of Corrections is wrong, this person is entitled to release, and the courts would say to the Department of Corrections, you must grant medical parole. because the statute requires it, and to do otherwise would be an abuse of discretion. And that's what we did. The courts enforced the statute against the department. But there was a case, it's now a year and a half ago, Commonwealth versus Martin Macaulay. In the Macaulay case, the court decided with a concurrence and a complex opinion that the courts could not compel the Department of Corrections to do anything. That if the Department of Corrections wrongly denied a medical parole, there was nothing that courts could do except send it back to the Department of Corrections for a do-over. They couldn't compel a result. They could only compel a repeat of the process. So what we ended up with was a system whereby someone would apply for medical parole that deserved medical parole. The Department of Corrections would say no, even though they're wrong. We would take the case to court, and the judges say, our hands are tied under the Macaulay case. We can't do anything but send it back to the commissioner. We can say, please look at this again. You made a mistake. And the Department of Corrections would look at it again and say, well, we don't want to. And we'd go back to court. The court would send it back. And we are now caught in a loop. So since this case, which says the courts cannot be used to make the prison do the right thing, there's no way to make the prison do the right thing. And so they don't. And the number of medical parole releases has dropped drastically. It's over, basically.
One question I have for you, and I think our listeners might be interested in, could you describe sort of a case maybe where medical parole, in your view, is warranted and where they're just not giving it? Could you tell us a little bit for folks who just don't understand what we're talking about here? Like, we keep using this term compassionate release, and people are sick and people are old, but can you paint a picture for us of maybe someone who is just languishing in prison who doesn't need to be?
Oh, there are many. The wards of the prison hospitals are full with people who are on oxygen tanks in wheelchairs. And the Department of Corrections says, well, he could order someone else to commit a crime if he were out. He could conspire with another. We have convicted burglars. You know, they're never going to be second-story men again. They have no legs, and they remain in the prison. We have people who are in the prison where medical parole is granted to them perhaps 72 hours before they die, so that it looks as if a medical parole were granted, but in fact, they're never released. They're not even unchained from the hospital bed. They're still awaiting a formal release plan. Medical parole is granted, and they die, granted, but still chained. So it looks like a grant on the stats, but it's not.
I wonder if people appreciate, you mentioned casually, sort of like as you were telling this, about the prison hospitals. I mean, things are dire. Some prisons have turned into geriatric wards or the equivalent of nursing homes, but without the staffing or the training or the expertise or the resources to adequately care for people.
Well, we would be mistaken. We would be siloed to believe that everyone feels the same way on this. Victims are entitled to hearings in murder cases on request on medical parole. And very often the grieving family, the injured family, will say, I want that prisoner to die suffering and in chains. He killed my husband, my daughter, my wife with cruelty and atrocity, and he deserves to die there like that. And it's not an uncommon feeling for a family to want revenge. The state is not supposed to operate on the basis of revenge, or at least not on revenge and retribution only. But the office of the district attorney is an elected office, and prisoners have no vote. And often the families of prisoners have no vote. So the result is not everyone thinks it's bad for a person to die in prison. Not everyone thinks it's bad to give somebody a death penalty. These are not shared views among the entirety of the population. So I don't think it's that people don't know. I think people disagree on what should be the appropriate lifelong consequence of a crime that a person is convicted of, such as this. There's a gentleman, Mr. Carver, who had a brain tumor and is in a wheelchair, who was denied medical parole on the basis of his crime was too terrible. A building was set on fire and many people died. And just this week, he actually prevailed on a motion for a new trial. He's now unconvicted. He might not even have done it. There's no conviction. He's now pre-trial. He's been in jail 40 years and he had a brain tumor. I was incapacitated and he was deemed to be too dangerous because he could say to someone else, strap a match. But on the other hand, you could see a group of people legitimately feeling that if indeed you did light a house full of people on fire, maybe you should die in prison. Maybe it is never safe for you to be released. And maybe even if it were safe, it would still be unfair to the people that died. I don't make fun of that belief. I do think it should not be a government policy, but I don't dispute an individual could have that feeling in good faith. I just think it ought not be the law. And I know it is not the law.
What would you say when someone made that argument that someone deserves to suffer and spend the rest of their lives in prison?
Well, that the law is not an instrument of private vengeance. The law is what the Supreme Judicial Court of Massachusetts says it is. The law is what the legislature says it is. The law is not what a particular injured person wishes it would be. And I say this with all compassion. If someone were to slap my child, I would want them to die in terrible suffering. But that's not the law. And I mean, that would be how I would feel. But it would not be my understanding of what the law is, and it wouldn't even be my understanding of what the law should be. And we're a system of laws and not of men. We're not a system of private justice. We're a system where an elected body decides what's good for the common good, and the court interprets what the legislature does. And so far, 300 years, it's mostly worked out.
Why do you think that's how the law should be, that the law should permit compassionate release or medical parole or geriatric release? Like, why do you think that is?
Well, we come to the theme of second chances. I mean, I don't think there's any evidence-based research that shows that society is improved by having either the death penalty or life without parole. I mean, people don't recidivate after the age of 55, only a very, very tiny percentage. There's what we call an age desistance curve. Most crimes are committed by people between 18 and under 25. I mean, people age out of crime. So why are we keeping them there, and at whose expense? I mean, when you think that it costs $600,000 to keep an old man in the prison, and for $600,000, you could hire 12 kindergarten teachers. You could have 12 more kindergarten classes. And you say, where are we putting our money? For one family's private vengeance, or as against 12 full kindergarten classes who could be reading The Cat in the Hat together in a little room with the rug? I mean, why? So I think we balance the cost of a retributive justice system against all the other things we could be devoting our resources to. That's where I come out in the balance, because nobody says, there's no evidence. I don't want to say nobody says, there's no evidence that proves these long terminal sentences do anybody any good except for satisfying a feeling of revenge.
Yeah, it's a complex subject. It really is, because there's also a question about human dignity, right? And just because you have caused great harm, tremendous harm, and you should be held accountable, does that mean that you forfeit your life forever? Does accountability require death in prison, even for really serious offenses? And I think you're right. There are people who fall on the side of, yes, it does require that. But there are others who sort of say, maybe not. Maybe we don't need this to keep society safe, to hold people fully accountable and still serve justice, whatever that means.
Well, that's why the Eighth Amendment is so wonderful. It's my favorite amendment. I mean, I like 4, 5, and 6, but 8 is my favorite.
Really? Mine is the Sixth Amendment. Mine is 6. Yours is 8. Huh, very interesting.
Because 8, you can make it happen. 8 is a constitutional right you can create. You can turn to the public. It's interactive with the legislative process and with human feeling and the media and the development and religion and culture. The Eighth Amendment protects people by looking at how are people now thinking and feeling as the world grows, we hope, more compassionate, more understanding, and also more evidence-based.
The Eighth Amendment refers to this idea of cruel and unusual punishment. It says punishment can't be cruel and unusual. And what you're talking about is evolving standards of decency that comes from the Supreme Court, where they say, like, hey, we need to check in with what's happening in the world, what's happening among the states, and make decisions about that and evaluating whether a punishment is cruel and unusual. But let's move that into a place where it recently really resonated. And you were, again, right at the heart of it in legislation in a court battle in Massachusetts about life without parole as applied to emerging adults. So go back to what you were saying, but if you can, tell us also about how that relates to what you did in the context of emerging adults in Massachusetts.
No, people use the language emerging adults, and I push back at that because I say what they really are is very late adolescents.
You're not wrong.
They have not yet emerged. They're hardly into the process. They're really teenagers. Certainly 18 and 19 are teenagers. 20 is a teenager. These are young people with all the attributes of youth that belong to people who are 14, 15, 16, and 17, or at least most. These are very young people. And this is where neuroscience, developing neuroscience, confirms what the court says every parent knows. These are young people. They're going to do stupid stuff. They're going to make bad decisions. They're going to be overly influenced by their peers. They're not going to be able to think when their emotions are really high. That's going to go away. They're not the people yet who they're going to be. They're people in this status adolescence. When you do stupid, risky, dumb stuff that you won't do when you're grown up, and it's impossible to know which of these stupid, dumb young people, risk-taking young people are going to stay that way, and which of them are just going to follow the desistance curve and just be regular people who will be perfectly safe to walk among us, contribute to society, and be a person who said, wow, I rode that stupid motorcycle in the rain when I was 18. I don't do that now. Now I have a Volvo.
So let's set the stage here. The Supreme Court, in a whole bunch of cases, has said that for people under the age of 18 who commit a murder, they can't be sentenced to a mandatory life without parole. A court has to at least consider, is that sentence appropriate for that person? And the Supreme Court has also said for anybody under 18 in a non-homicide case, life without parole is off the table. And that has had a huge impact around the country. People who were sentenced under the age of 18 to life without parole have been having sentencing rehearings and having their cases reconsidered. But a bunch of folks have realized the neuroscience doesn't say 18 is this black and white number. Folks are evolving and changing and emerging into their adulthood. It doesn't happen magically at 18. And so some states have considered whether to expand the cutoff from 18 to something older. And that's where you come in. So what happened in Massachusetts? What was the case of Commonwealth versus Sheldon Mattis? Tell us about that, how you came to be involved in that, and what the court said.
Massachusetts is a city on a hill. We are a leader. We are the only state now to absolutely prohibit life without parole for anyone under the age of 21. We are the first. We are a leader. It took a long time. It took a village. It took litigation since before the United States Supreme Court decided to rule for under 18. This has been in process for a long time. Many really great lawyers worked on it. Mr. Mattis was my client early on, but many have joined, many took over. Everybody contributed. It was a national triumph. And It was a vote of 4-3 by our court. Once again, reflecting the change. There was a Mattis case one when we started with Mr. Mattis in the Superior Court, and we said the co-defendant is 17 and 11 months. Mr. Mattis is 18 and 4 months. Why does one get 15 to life and the other gets a mandatory life without parole? They're only 6 months apart. How can that be right? And what we argued to the court below, way back, the emerging neuroscience shows there's really no difference between 18 and 17. So there can't be a difference in consequence. And we got a response from the Commonwealth. The Commonwealth said, of course there's the same. We don't contest that neuroscience will show that they're the same. We just say there needs to be a bright line rule. And we went up on it. So we weren't allowed to have money to have experts. We weren't allowed to put on colored slides. We weren't allowed to make our proof because the government agreed. 18 and 17 are the same. However, you still lose. We got up to the Massachusetts Supreme Judicial Court. We argued they're just the same. Therefore, the punishment has to be the same. In the court, we had what was extraordinary at the time. We had the agreement of 2 district attorneys that Mr. Mattis was correct and that a mandatory sentence of life without parole could not constitutionally be imposed. This was extraordinary, that the 2 district attorneys' offices in our state joined with the defendant on a brief on an issue. It had not occurred before. And Judge Gantz, the late, great Chief Justice Gantz, took notice. And for the first time, the court was prepared to seriously consider this question because it wasn't just me litigating in my attic. It was me and 2 DAs. But the court said something in jurisprudential, formal language. The court said something like, but Ruthie, we don't have any science here. And I said to Judge Gantz, I said, well, you can't blame me. They agreed. I couldn't get any money. They agreed the science is this. So what more can I do? They said yes. And he said something like, the chief said something in fancy lawyer talk, which was like, Ruthie, we're a court. We have to have some science pages here before we can do this. And I was like, Judge, he said I was right. And the judge said, we're the court. We have to see science here. And that was a big breakthrough too, because what Justice Gantz did was say, go back and get me some science. And then we needed the team. We had wonderful experts. We had fabulous co-counsel. And in the end, we did not have the district attorney in the district in which we were litigating said, you're right. It's just like we said before. They're the same. We maybe disagree about the remedy, but the people, our opposition said, look, 10 months apart, how can it be a difference? And so we came back. That doesn't mean we didn't litigate. We went up, we went down, we went back, we went forth. We had more hearings. Another case with a very famous, wonderful lawyer, Rosie Scapiccio, joined us. She had a client in the same position. She litigated with Dr. Steinberg from Philadelphia, who had been the expert from the original cases. It was a wonderful piece of work by a large group of people. We were supported by the retired judges of Massachusetts. We had national briefing on our behalf. But again, the court shifted right. Justice Gantz, who had invited us to come back with the science, wasn't there anymore. We had a Republican bench. We came back and they were like, we know we said, just show us some science. And we know you showed us the science, but, and we came back with the 4-3. And that's how it happened.
It is an amazing thing because there has been some movement around the country. And I mean, Mattis is a big deal. It's a really big deal. But in DC, people have an opportunity for resentencing under the age of 25, I think it is. I think Illinois has done some work around this. California's done some work around this. So, if you really look at what the neuroscientists are saying, they actually sort of say it's really about 26 when things fully shift, when you are kind of like formed. And I want to be clear, I'm a big believer that people can change throughout their lives, but 26 seems to be kind of like when you're neuroscientifically developed. So how did 21 come to be the number? Do you know?
Well, of course I know. I picked it. And I can tell you why. And it's because just generally for an audience, which is lawyers and not lawyers, litigators make strategic choices. We wanted as a group, me and my brilliant co-counsel, we wanted something we could win. In order to win, we wanted an absolute unanimity of scientific opinion. We didn't want a few out there people showing a trend. We didn't want a place where there was disagreement. We wanted to bring it at an age where agreement was universal. And most experimentation, psychological experiments or fMRI experiments, are done on college campuses because you can get participants to do an MRI scan in exchange for an Amazon gift card. So it's just an incidental factor of history that researchers stopped their experiments with college seniors because those were the people that were there. It's much harder to go out in the world and find a bunch of 22 to 26-year-olds who are available to come in 4 times and get their brain scanned, and they won't do it for a gift card. So the research, the enormous body of research, was restricted in unanimity up to age of 21. So that's why we picked 21. It doesn't mean the science stops at 21. The other reason we picked 21 is because the courts look at historical markers of maturity as well. And they were very interested in this question. 21 has long been viewed in many contexts as an age of adulthood. I mean, there's always argument, well, you can serve in the Army when you're 18. So if you can be in the Army, why aren't you an adult for all purposes? You can vote at 18. Why aren't you an adult for all purposes? And we try to answer to that. We talk about the difference between what's called hot and cold cognition. And what science shows us almost universally is that a person of 16 in a time and space where he or she is independently thinking is going to think as well as anyone else will ever think. At 16, you can do a math problem, you can do a puzzle, you can read a poem, as well as anyone who's 26 in a room by yourself, reading, working, reasoning, solving a maze. You're just as good at 16 as 25. Your cold cognition is really almost at its peak in those late teen years. The problem is when you're not in cold cognition, but in hot cognition, when you're in the moment between 16 and 25 and absolutely proven to 21, you lose your ability to reason because you're young. The skills that you have when you're calm and collected really pretty much disappear if you are in a fast moving car with a bunch of other teenagers. So like when you're driving with your mom quietly,